So I'll start then with how I got here. So as I said a moment ago, I did law at read law at Trinity Hall 1989 to 92. Trinity Hall is almost the opposite to Trinity, a very small college. And of course, for the first few years of my life, I had to tell people, no, it's not Trinity, it's Trinity Hall. And now, of course, it is Trinity, not Trinity Hall. But so I enjoyed reading law, wasn't quite sure whether I wanted to be a solicitor or a barrister. So when I graduated, I worked for the Law Commission for 2 years, which is a sort of quango, a semi-independent law reform body who look into various reform projects. So I worked as a research assistant there for 2 years and then decided to go to the bar. So I was called to the bar in 1995 and joined Fountain Court Chambers, where I've been ever since. Fountain Court's a very broad commercial chambers in Middle Temple. And I practiced full-time for 8 years. So I started as a barrister, junior barrister, and did a wide variety of commercial work. I did, for example, I did the hepatitis C blood transfusion case, defective products case. So when the defective blood products contaminated with hepatitis C gave people hepatitis. So I was the junior on that case. I did some aviation work. So it was a very broad commercial practice. And I did that for a full-time, as I say, for about 8 years. And then I got to the point, and there were various reasons for changing emphasis. Partly, I tended to do very big cases. So I was very rarely on my feet myself. I didn't ever really love cross-examination and never got very good at it. So I felt that I was always drawn to the more academic side of the law than the real sort of hardcore advocacy performance aspect. So that was one thing. So I felt that the longer that career went on, that might become more of a problem if I never really relished that advocacy element. And we also, so I'm married to a lawyer, and we had our first child, and just being entirely, have 2 commercial barristers trying to do a full-time practice is not very easy. But I was lucky because actually all things pointed in the same direction for me. So I decided to try and sort of also have an academic element to my career. And I was incredibly lucky to get a college teaching job at Trinity, which I applied for. There were a few jobs. In fact, I had an interview at Trinity Hall, which I didn't get the day before, and then got this job at Trinity. And I don't know how easy it would be to do this nowadays. I mean, I think this is 20 years ago. People didn't tend to do law PhDs then. So coming from practice, and I did have quite an academic practice, so I'd done a bit of writing, that was still a route into academia. Now, I'm not sure how easy that would be now, but I was very lucky to get that teaching job. And so I became a college teaching officer at Trinity, taught contract law, commercial law, conflict of laws, was director of studies. Then I got a university job. And then since then, I've then become a university reader and now a university professor. So that's been my academic career. Oh, and I also got a PhD through publications. I don't know if anybody's ever heard of that. So if you become an academic and you haven't already got a PhD, you can use your books and articles to apply for a PhD by special regulation. So I did that. And in the meantime, I've also kept, firstly as a door tenant and more recently as a main tenant again at Fountain Court, and have tried to keep up an element of my practice as well, which has come and gone. I've been doing a bit more recently. Now my children are a bit older, so mainly jurisdiction and choice of law things. So now I try and do a bit of both. So is that the path? Is anybody, that's a sort of nutshell how I got here?
Fantastic, congratulations. You missed, of course, your latest achievement now to become Vice Master of Trinity.
Yes.
How did you manage to do that?
Well, so I think, I mean, I have been very lucky. Quite often my students, I think quite a lot of people, lawyers, particularly, my students will say, this is slightly backtracking, but it's very attractive, I think, to have a part academic, part practice career. And I think I've been very lucky to achieve that. And I think you can either do it by more practice and then go into academia, which I'm not sure which is the easiest way. I suppose I did it that way. I think that has become harder. So I think I'm very lucky to have got those two elements.
As your student, I think maybe that made you my best professor. Juliana, as your student, I think you coming from practice made you my best professor. I learned the most from you immediately.
Well, that's very nice.
I mean, a girl lawyer.
I mean, I do teach, the things I teach are very practical subjects. So when I come on to talk a bit about my academic work and my practice, I teach mainly conflict of laws, private international law, which is a very practical subject. So if you were a legal historian, obviously being in practice is not, you know, or a Roman lawyer. So I'm not saying that all academic law needs to have that, but I think in the particular things I teach, even contract law, but certainly private international law, it has been really useful to do both. And I think it actually really complements the two. So that's been quite an easy thing to combine in a way because of the field I'm in. Yeah, so Vice Master sort of was really that really was not planned. So about 6 months ago, we needed a new Vice Master. And as these things happen, a couple of people said to me, oh, you'd be good. And the first person I ignored, and then the next person said, you'd be good. And I thought, well, so I suppose why I agreed to have my arm twisted was partly because I think that having the sort of background I've got makes it much easier for me to do the job than many people. So I think we've got, as you all know, some amazing people here. But, you know, a Rebecca Fitzgerald who's busy curing esophageal cancer, she couldn't be coming from her lab where she's doing a very sort of all-engrossing job. To be Vice Master would be very hard. So I think there's a lot of people who just couldn't do it. I think because my research is much more practical, and I'd also already reduced my hours at the faculty to allow me to do more practice, I think I at least had the flexibility of being able to do it. I also think that being a lawyer, you know, turning your hand to the audit committee or the college council is easier for me because it's a bit like my life anyway. So I think it's easier for me to spend an hour reading the papers quite quickly, and I can digest the material quite quickly because it is sort of my world. So I felt that was an advantage that some people wouldn't have. So I actually felt there weren't that many people. If somebody else brilliant had appeared, I almost certainly would have let them do it. But, you know, I thought, well, actually, I can do it. I've also got more time. My children are now 18 and 21. So I was filling my empty nest. So a couple of people said, oh, you'd be good. And then like one of these things, you say you'll stand in the election and then you win, and then lo and behold, you're Vice Master. So yeah, it was not much planning, I'm afraid.
I saw you were involved, it says here, in a disciplinary appeal hearings for Trinity College at University Court of Discipline. It's not quite clear what that exactly means, but it seems you have been involved with your legal practice applied to the university world as well.
And actually, that's a really good point, because I think that's this would be another way in which, when I really thought to myself, well, have I got skills that would be useful? So I sit on the University Court of Discipline has to have a lawyer chairing it. In fact, it's changed very recently, but certainly up till now, it's chaired by a lawyer, and then they have a panel of 5 senior academics. And it would be the most serious disciplinary cases coming from a college. So there's an interesting interface between college and university in this respect, but sometimes a college will refer to the university a disciplinary case, which I was then in charge of hearing. Often plagiarism actually was the main thing.
Oh, I see.
Really?
So cheating in exams, people would take a mobile phone into an exam.
Or students, okay.
Yeah.
Oh my goodness. So there was a reason for all the checks we had to go through and flipping through the pages. I can't believe it. Wow. Yeah.
So and of course now everybody's in their rooms on computers doing their exam. It's a whole different ballgame. But yeah, so I did have that role. And the other thing I did, which was really interesting, is fitness to practice. So for medics and vets who are studying, if you get yourself into trouble, it's pretty serious, these cases. You then have to, as well as having the possible college and university discipline effects, because of the way that those professions are run, there's also has to be a fitness to practice procedure where,
like the bar in New York,
so that they can't then go to another university. If it's sufficiently serious, you can say they're not fit to practice at all as a doctor, say, for 5 years. So I also chaired, I've done quite recently actually, a vet and a medic in that capacity. Wow. So I mean, they're important because I think the procedural aspects of discipline hearings are so important, and it's so easy to go wrong. I'm sure you'll have all seen various colleges who've got themselves into trouble with usually the procedure actually of how to handle complaints that I think at least I've had, and I'm a lawyer and I find it really difficult because it's just, you'd think it was easy, to be fair.
Has these mostly involved students or faculty as well?
So those two things are students, because they are, I mean, I have also done staff disciplinary things for college, but there's usually two separate procedures, but the fitness to practice and court of discipline is students.
Gotcha.
One of them.
Yeah, it's just really difficult to get it right, and it's really important to get it right. And I still don't think I know all the answers, but at least I've had some experience of that I can bring. The other thing, I was a school governor. The Trinity nominates a governor to the Perth School, which is a big school in Cambridge. And that actually taught me some really good governance things. So, for example, I was on the audit committee there. So actually, I sort of thought, well, actually, come to think of it, I've probably got some governance experience.
Louise, I can't think of anyone more qualified.
This is my manifesto. I'm now repeating my manifesto. Well, we had to do a CV. I mean, there was nothing worse than the election was the most dreadful. Well, I found it very stressful. Luckily, there's a sort of convention that you don't campaign, so I didn't actually do any campaigning, but that's really not I didn't relish being involved in an election, but yes, I've just repeated my CV that I said all the skills I would have. But actually, those sorts of things have been incredibly useful. So I chaired the audit committee for the first time yesterday, and it's really hard. And if you've never done, I mean, so I have been on an audit committee, and also I've read accounts through my job, but I sort of think there aren't that many people. You'd have such a learning curve if you'd never done any of that sort of thing. So yes, so becoming vice master definitely wasn't at all in the plan. But then I thought, well, it has meant I'm having to do a few less cases. I think that's the thing that will probably, for a little while, at least until I get used to it, I'll have to make some time that way.
But it's wonderful to have two women at the top of Trinity. It's very,
yes.
very wonderful. It's, when I joined Trinity as a PhD student, I think it was the first time women were admitted as undergraduates, I think. It's not that long ago.
And because we have, of course, life fellows, there are a lot of, it's still quite a male-dominated fellowship, simply because the 65 retired fellows are all men. So by the time you get to the first woman, you're already halfway through the list of fellows. So it is, and it's nice to work with Sally Davis, who's a very interesting person and very nice to be. Yes, as Phil's pointing out, our senior tutor's also a woman. Although Phil, I also know that we haven't yet had a senior bursar who's a woman. So I'm sort of thinking, wait till they let us get our hands on the money. I think that might be the real glass ceiling.
The important issue is, of course, also that you are a big role model for, like, Juliana, for example.
Exactly,
and,
exactly.
So it's not just to have a diversity in the management aspects, but also the importance of a role model, I think. Also for men, I think to have women in important positions as role models is also very important for men to get a different view on Tamalia, of course you're allowed to ask.
Yes, please ask anything.
Please ask. Tamalia?
Well, since you are the deputy master of the college, and since you have experience with governance, I wanted to ask you if one wants to appeal something that the alumni office has decided, if an alumni association in Indonesia wants to appeal something the alumni office has decided at Cambridge, who does one go to?
Well, I don't know the actual answer. I can tell you a sort of process answer. Usually, so I just don't know the answer to that, but I imagine that there is we have various policies in college for, I mean, as I talked earlier, staff are different from students, are different from fellows. So I imagine there must be a policy that would presumably cover that, but I'm afraid I don't know the actual answer.
Are you talking about the Trinity College Alumni Office or the University Alumni Office? Because that would be different, I guess.
The Cambridge University Alumni Office.
Okay.
How do we find out who we can go to appeal something?
I'm still not quite sure I understand the question. So you're wanting to appeal a decision made by the university or made by the college?
Yes, so the Indonesian, we have Oxford Cambridge Society of Indonesia, which has been around for 30 years. And now the office wants to shut us down and we would like to appeal it. So who do we?
Sorry, did you say the university would like to shut you down or Trinity College?
Yes, the University Alumni Office. The University of Cambridge Alumni Office wants to shut us down and we would like to appeal the decision. So who do we go to appeal?
So Phil's got to just put an answer on the chat. Yes, I mean, that was what I was about to say. I would probably, that they must have a procedure, but I think you would probably need to talk. Phil's got a suggestion of somebody to talk to at the University Development Office. I'm sure he'd be happy to put you in touch with that person.
Mario, if you don't have Phil passes from the Trinity Alumni Office. If you don't have his email, I can put you in touch after our video, after our Zoom event here. Do you want to do that?
Okay, thank you.
Maybe,
yes, please.
You can find
sorry, I did not catch. Sorry?
Phil Pass is, he works in the Trinity College Alumni Office. And he's here in our Zoom discussion now, and he wrote down the email, and he can help you, I guess.
Yeah, if you look at the chat, he's
email to Phil Pass.
Yeah, he's put his email address in the chat.
Okay, I will contact him, and then I will contact him to ask about that. Thank you. I don't want to disrupt the meeting with an Indonesian question. Thank you.
Well, I hope that's
important. Thank you, Tamalia. Very, very important.
So Gerhard, do you want me to carry on with Vice Master?
Yes.
Yeah.
Well,
so
could you? Yeah.
I mean, if you can tell us, like, if we are right in the middle of Vice Master discussion. If you tell us what kind of your plans is, what to achieve with your work at Trinity, and your view on the further development of the college as well. So, I think that would be very, very interesting for all of us.
Yes, so I mean, the role is, so when I spoke to Professor Worcester about what the job involved, he gave me a sort of table. Let's see if I can show you.
We had a Zoom call with him before as well.
Yeah, so this is the table he gave me that's got Vice Master duties, committees chair on one side, of which this should just give me a flavour. So the committees I chair are the buildings, audit, expenditure, stipends, catering, high table, feasts, memorials, visiting scholars, choir, library, house, long-term planning. And then I'm also a member of the council, education, honorary fellows, title B and D. So it's a long list. So some of what I do is go on all these committees. And in that sense, you definitely have a strategic role. I should say, sort of before I go on to that strategic role, it is also, I think the idea of the role is to be the fellow for the fellows. So if we think of the tutorial department in college is for the students mainly, and for the teaching of students and the teaching staff. And then we've got the junior bursar who runs the staff, and the senior bursar runs the bursary and the money. Really, I think the Vice Master does everything that's not all of those things. So it's really things to do with the fellows and the fellowship that aren't. So it's not the students, it's not the money, it's not really the staff. It's sort of everything else.
So you have no bandwidth, or I mean, within your mandate, there's no bandwidth where you have decisions over, with setting up overseas funds or accepting donate.
Well, so I'm also, in fact, I happen to be a member of Alumni Relations and Development Committee, and always have been. I've been doing that for a long time, just as a fellow. So I've always been interested in that. I would now be on that committee as the Vice Master anyway. So fundraising.
For example, if my investment bank was interested in setting up a program for, undergrads in math or law to spend a summer working, working here in New York. Or to set up some kind of scholarship, or to, strategically earmark, donate money. That's kind of what I was curious about.
So that would be alumni relations. And the Vice Master is, I think the Master chairs Alumni Relations, but I'm on the Alumni Relations Committee, so that would be something that I would be involved in, yeah.
Okay.
So, so I think that the thing about being Vice Master is it is important that you sort of know about everything that's going on, which I think coming on to what the future plans of the college are, it does need some people who at least understand what's needed for students, what's needed for the building. So I'm also a chair of the Buildings Committee, what Alumni Relations are doing. So I think some of what I need to be able to do is sort of have an oversight of all those different things that are going on in the college. In terms of the college's plans, so I've sort of thought about three things. I mean, I've only been in it for 3 months, but the sort of three main things that are both current and future plans. I suppose the first big thing that I was involved in was setting up the Ukraine fund. So when the
amazing.
Yeah, well, so when the crisis happened, of course, one of the problems in Trinity is it often does take a long time to get anything to happen, partly because of the governance, and just so we sort of got together and managed quite quickly to get a fund of £250,000 so that we knew we could react as and when money was needed. So we gave, so there's sort of various elements to that. Partly it's supporting studentships from Ukraine students and also Russian students who have had to leave Russia because of their support for Ukraine. So, and we're doing that through giving money to the Cambridge Trust, who have these Rowan Williams studentships. So in some ways, it doesn't make sense to necessarily reinvent the wheel for everything. So in fact, that was a good way of doing that, because they've got this very well-established studentship scheme. So we've given them some money to enable them to do that. In relation to academics, we immediately got in touch with CARA. I don't know if you've ever heard of that. It's an organisation for refugee scholars, which was an existing organisation, and they've now got a association with the British Academy specifically for Ukraine academics. And what we're doing with that, it's one of those things where it's a bit hard to know how to help in the best way. And what's become clear about that what they need is sometimes a college to back the application to the British Academy, for example, by providing accommodation. So in one case, in fact, this scholar's just managed to get a British Academy grant. So they're going to join the English faculty, and what Trinity have been able to do is provide them with a flat for him and his family for a year in the first instance for when they come. There's another scholar who's joining the psychology department who we're making a visiting scholar so that they can have dining rights, partly financial, but also so they can come and meet people in Cambridge and make some connections. So, and because we've got this fund, it means that we're able to respond a little bit in a more slightly agile way. When somebody makes an application, we're able to say, well, we've got the money, and if we can find a flat, then the money can come from the fund.
Gotcha.
So that was the sort of one of the very immediate things that happened. Another thing that we've just done is in relation to widening participation. So you know that this is always an issue for the college, how to attract not just the best students, but diverse students. And we've recently agreed to make an additional maintenance grant. This you may have seen it on the website, for students who would qualify for a bursary. So there are already bursaries for students whose parents earn less than a certain amount, and we're going to top that up a bit because it was in some cases only about £3,000. So we're making an additional
providing more to
cover accommodation, for example.
Okay, gotcha.
And it's a 3-year pilot study. The 3-year pilot thing. It's partly a sort of way of helping the COVID generation as well, and it's partly to help those students, and it's partly to try and make it clear that we are an inclusive college who really do want to attract that kind of students. There's a messaging problem because Trinity does have a reputation of being very rich and grand and, perhaps off-putting to some of the sort of broader widening participation type candidates. So I think that the messaging is quite important. So by doing this, we're hoping that we're sending a very clear message that we are really interested in attracting that kind of student.
And is that grant available to international students as well, or overseas?
No, I think that the overseas, it's conditional, it's tied to a Cambridge bursary. So I don't think Cambridge bursaries, I'm not sure about the answer to that. So if you can get an existing bursary, it's a top up of that. I think with international students, we have all sorts of different, so I am on that committee now, so there are lots of international studentships.
Yeah, I was a EU not quite resident, but being EU citizen, I got a little bit of a deduction.
Yeah, and in fact, another thing we did, so I've only is on the international studentships committee. So as I'm sure you all know, I mean, Trinity gets the most unbelievably strong international applicants, particularly in maths and science, but also in law, obviously. So we found when we were doing those studentships that we're almost spoilt for choice. I mean, the standard of the applicants for, let's say, maths are unbelievably strong. But we started to feel that, but then we had an applicant from Nigeria, I think it was, who wouldn't have been the top of the maths list. That's what I'm trying to say. So wasn't the top candidate in maths, but had got an offer, and it became clear that they wouldn't be able to come if they didn't get money from this studentships committee. So what we've actually now done is earmarked a new studentship for people from very low incomes, from countries where we're really trying to attract students, rather than having to have a debate about, well, that's knocking off this amazingly clever mathematician. We've now got a different sort of international studentship so that we can be flexible about people who've already got an offer but can't come if they don't get the money, and for a particular reason we want to support that student. So those are, and those are sort of things that the college are always trying to improve on. The thing that I would say is my own, the thing I'd really like to do, and the thing that's really excited me, which is a sort of new thing, is that we're going to do a master plan. So I don't know if anybody's ever had any experience of a master plan. So I did actually, the school where I'm a governor did a master plan, which was useful. So I have seen how this works, and some other colleges have done it recently. So the idea is that you get, we had a competition. So I think we had 8 architects firms on the long list, and then we had 4 on the short list. And it's a process whereby they come in, and the first stage is to do a huge consultation with really everybody in college, students, staff, fellows, alumni, every department. So you'll go to the gardeners, you'll talk to the kitchens, but particularly find out what students want.
Entire social infrastructure of the.
What students think work well, what doesn't work well. An obvious answer, I'm sure, will be that students now like to have working spaces where they can all meet and work together. So there's definitely been a change, and I see this from my own children, that rather than go to the library or work in their rooms, they like to go and work in a cafe with other students. And actually, it would be good if the junior research fellows could also have a more interactive workspace. So you do this very broad consultation. You work out, the architects do a sort of, it's based on the physical environment of college, but with a really strong element of what do people want, what do they use, what are we using well, what are we not. So it will also map the physical estate. So from the main college site across to Burrells Field, what have we got now, what are we using, what are we not using. And the idea is that process in itself, I think, will be really helpful for Trinity, because it'll help to build a sort of consensus of the things that we want to be doing, what are the important things that we need to change about the experience. So what will make us a really attractive environment for the best students, the best researchers, the best fellows. And then they map the current physical environment, and then what they tend to do is give you options. They tend to explain what's being used well and what isn't. Then there's usually some sort of low-hanging fruit. You could move this to there, or do this, which is a relatively small thing. There might be some longer term aims. So it won't be a particular design. So something like the brew house or Oldfield, which obviously could be better. They won't say, here's what you should do with Oldfield. They'll say, well, you could have a graduate hostel there, or you could have a new sports facility, or it might be better to have the sports facility where the wine cellars are, or this is a silly example, but maybe you don't want to have the bar there. Maybe you want to put the bar in the old wine cellars and have the bar as a cafe. So it's that idea of identifying physical projects to do, but very firmly based in a consultation of what we think the college looks like now, what it should look like. And it'll take about a year. And I'm just really excited by it because I think it will really give us a way, hopefully, of building some consensus about some things that we should think about doing. I think it'll be useful to work with, and I've already talked to Michael Banner about this and Bill, because it will be useful. We're going to have some alumni involvement right from the beginning, and in the context of a possible campaign, it will be useful to see what people are interested in supporting. So I think it'll be a really good thing for the college and a really exciting thing to be involved in.
And what stage of the process are you in? You said, are you?
We've just chosen the architects.
You've just chosen, and have they given you? Are you allowed to disclose what the budget estimate they've given you is for the year?
Can I just? Yes. Well, so interestingly, when we were choosing, I mean, it was really hard to choose. So we had 4 architects, and it became quite. The choice really came between 2. One's a very well-established, medium-sized English firm who do a lot of master plans, have done a lot for other colleges. They'd had some input into the new Northwest Cambridge site, a very interesting development in Cambridge called Accordia, if anybody knows Cambridge. So sort of slightly more traditional firm with a lot of college master plan experience was one choice. And then the other choice, who were an American firm called Arup, who were a very big firm, would have been a very different, they'd have been a lot more blue sky thinking, I think. I think it would have been much more challenging. I should say we didn't choose this firm, and we had a lot of agonizing about
There's
this.
also cultural, I mean, there are,
They would have had some, I think it would have been much more challenging for us, because I think they really would have got us to question really big issues about where does the college want to go, which I think in some ways really excited us. But then I think we, in the end, felt that actually a master plan is quite an exciting thing to be doing anyway. So maybe we need to go for the slightly more boring conservative master plan rather than go
or build up to a total overhaul of
and a bit my worry
notoriously entrenched system.
Exactly, and also with some limitations. So I'm absolutely sure, having had children who've gone to university, friends is they like to have 6 or 8 bedrooms and a big kitchen where you can sit and work and socialize in that sort of environment, and we just can't necessarily do that in a college environment because we're staircase driven and we're dining hall driven. So in some ways, I think having a firm that at least knows some of the really difficult things, and of course the counter argument is, well, maybe this blue sky thinking would have thought of a way of dealing with that, but I sort of felt we've got quite a long way to go in this, and we're coming from quite a standing start. So maybe, and I was challenged on this, and the master said to me, are you really challenging yourself? I mean, people did say, should we be doing that? Also would have been much more expensive. But I sort of felt in the end that Trinity, as you all know, is quite things don't change very easily. So I think actually having a master plan at all, even a slightly more traditional type of master plan, I think will be really good. So we did slightly play it safe, which I'm sort of apologizing for, but that's what we decided to do. I mean,
I think that playing it safe will have huge impact changes going forward.
I mean, it's so I've already found on the buildings committee. So we were talking about how to deal with, we've had an accessibility report, and we need to do something about Great Gate because there's some steps, and should we have a lift or should we have a ramp? And this is the sort of thing that at Trinity we can spend years discussing and looking. And then of course we said, well, we'll ask the architects in the master plan. One of the things they will look at is accessibility, and actually would it be better to in fact come through Queensgate, and this is I think exactly the sort of,
and having an independent outside opinion
and what part of the process is. And they'll have already asked that, so we'll obviously get them to speak to the various, a student. Obviously they'll be talking to the students, but we'll ask them to talk to, we've got one fellow who uses a wheelchair, who can then explain the parameters, and I'm hoping it'll just be a really useful way of gaining consensus because of consulting and thinking about what the options, which I think is probably the best way to get consensus on the best thing to do.
Okay. And the only reason I asked for budget-wise is if you're raising funds for it still, that would be something that my company would be interested.
Yeah, so I think
would certainly be able to help with or contribute to directly.
Yeah. And I think it will be a really good thing with so I mean I am very involved in alumni relations, and I always have been, and I think it's a fantastic way of getting people involved either in the master plan or people will be interested in different elements of it, and it's really a good way of getting an input into what the best thing to be doing for the college is, but knowing that all the relevant stakeholders are being consulted. So I really do think it's going to be a really useful. So the example at the school I was involved in is that they've been discussing about various options. So should we have a new science block, or should we build a swimming pool? And that just seems like a really difficult, well, how do we know the answer to that? And somehow just having the process of the timing, and we could do this and that would stop us doing that, and the money, and the here's a vague design of where it would go, it just made everybody say obviously we should do the swimming pool. And it's hard to describe how, unless I mean, it is a really interesting process, and it's definitely something that more and more organizations are doing. So I'm really excited about the master plan, and so is the master, and I think both of us feel it will be a way of making a difference both in the short term, but also to hopefully give some impetus to something like a brew house project as well.
Is that the first time Trinity has made such a master plan?
Yeah.
First time.
So what we've done before,
at least this century.
Yeah, well, exactly. And what's happened before is that we've had a design for the brew house, for example. So I'm going to show you. So that's the, where the cars are parked by where the pumps are.
Where the pumps
are. It's the sort of last undeveloped bit of college, the main college site, which is on the river.
It's like wooden barracks, I think, or
it's a sort of, it was in fact where they used to make beer. So that's what is a brew house. And there's an old building and there's a car park, and it could not be more ugly and unattractive and not used. But the idea of doing something on the river is so paralyzing, because every time you think of doing something, you think, well, what do we really need? Do we need an auditorium? Do we need a cafe? Do we need an underground parking? So first of all, you've got to get some idea of what the important thing to do is. And then we all just think, oh goodness, what if we mess up the river? It's a really important site. But that actually just means that we have in the past had some designs for that, but this, we're hoping that the master plan will find a way of building some consensus both about what we need, and then
prioritizing among
of what to use it for, and then also help through to some sort of architectural competition about how it should look. But at the moment we're sort of paralyzed into ending up doing nothing, which I think can be a problem.
Fantastic. Thank you so much.
That's really exciting.
Yes, very, very. Louise, if you like, it would be very interesting to hear about your practice and your academic work in law. We had Dame
Worthington.
She was telling us about equity. We learned a lot about equity. So I've seen that you are very involved in very big commercial decision making. So I think that's quite a different aspect. So that would be very, very interesting to hear from you. And I've also seen you're working a lot in international employment issues and large-scale commercial decision making. So that would be very, very interesting to hear from you.
Yes. So what my main research interest and practice really is in what's called private international law. So nothing to do with public international law, which is countries. Private international law, or they sometimes call it conflict of law, is the rules that a court applies to decide which court is going to hear the case and which law it's going to apply. In any big international case, you have to determine those two issues. And it sounds quite dry, but A, the rules are really interesting and complicated, and B, they're actually practically quite important. So
very important, yeah.
So the two main things. So my academic work, so I do all really elements of private international law, but my academic work has focused on international employment law. So, and of course, this is becoming more important, as you can immediately see, because the more people work in different countries, or let's say you've got an American bank whose headquarters are in New York, and they send an employee to London on secondment. So they could send them full-time for a year and then they go home again. Or they might work some of the time in America and some of the time in London. Or you sometimes have people who live in one country and work in another.
One of the most spectacular cases I know in this subject is Michael Woodford of Olympus. Maybe you've heard about this case. He was.
No, I don't think I have.
Oh, he's an Englishman who was hired by, Olympus is a Japanese company which has about 80% or 70% of the world market in endoscopes, on optical medical equipment. And he was hired to be the global CEO in Japan, here in Tokyo. He came to Japan, but he didn't know much about Japan at all. And so he was the CEO of this large Japanese stock market listed, very large company. And that company was hiding a large financial scandal, which was under the surface, and nobody knew about it. It was hidden by the management. And they were hiring Michael Woodford as a CEO and the other directors tried to hide this scandal from Michael Woodford. And to cut a long story short, it ended up in a huge scandal. He escaped Japan, and then in the end, he had an employment court case in London, where he was awarded a large amount of compensation, maybe 10 million pounds or something, I forgot the number, from Olympus. Now, he was suing Olympus for unfair dismissal or something like that. As the CEO, probably it's not unfair dismissal. That's kind of the most spectacular case.
And this of course happens more and more, because
where this international, the aspects you're working on, which law applies and which court he can go to, is super important, because Olympus, of course, wanted that in Tokyo, and Michael Woodford wanted it in London. So the core issue is not really the final decision.
Exactly. And funny enough, when I did the first edition of my book on international employment law, I remember writing to the publishers and saying, this was about 15 years ago, this isn't going to be an ever-increasing problem. And then I put in the first paragraph of my book, this is never increasing. Now there's global, I can't remember, something to do with global countries. And at the time, I was sort of making it up and thinking, I'm sure this must be right. And since then, there've just been so many cases. And this bit I put in my first sentence has been cited in the Supreme Court as some kind of, look, she knew. But I mean, at the time, I sort of just needed something to write about, thought this sounds interesting. But it really has absolutely exploded since. So I've just done a second edition because there have been so many cases. And it raises some quite interesting theoretical questions to do with what law applies and whether it should be the same for every type of rule. So let's say you're working for a US firm and you're 6 months in London and 6 months in America, and you're suing in London. Should you be able to rely on UK unfair dismissal law, for example?
What did your contract say originally?
And let's say, the contract might say American or English, but interestingly, our employment law expressly says it doesn't matter which law governs the contract.
Right.
If you're working, so we've made it a rule that you can rely on if you're working in England. But then the question is, do you have to be working in England all the time? And then there might be a question about, so in this case I'm thinking of, they were working just under 50% of the time in England for tax reasons and more time in America. Mm-hmm. So then the court said, well, you can't rely on unfair dismissal or redundancy. I think partly because your pay structure was an American pay structure. And you can see that if you're being paid more because you haven't got redundancy rights, for example, you
can't rely, exactly, you can't benefit both ways.
On the other hand, maybe it should be different for discrimination legislation, for example. So I've argued that you might have to have different scope for, well, and so for example, health and safety.
Yes, absolutely.
Yeah, and for health and safety, for example, you'd never say that if you're running a factory that health and safety doesn't apply if you're American, if you've got an American contract.
Right.
And discrimination, I think, really does come, interestingly, somewhere in the middle of those two things. So you may say that you think discrimination legislation should be more physical territory based rather than what law applies to the contract, because of the sort of, it's like
it's a protection versus a benefit, I think.
And criminal law is incredibly territorial. So even if you're only in England for 5 minutes, you can both rely on the criminal law and be subject to it. So there's an interesting question about how employment laws should exist in that spectrum. Although some judges don't think you should treat different employment rights different. Quite a lot of judges just think discrimination is the same as unfair dismissal, the same as redundancy. So that was, I think that's been a lot of my academic work's been about that. And of course, Brexit's made a huge difference because we no longer have any of the European rules now. So the common law rules have been amended, in fact, to take into account some of the European material, but that's been in sort of state of flux. So that's my academic work has mainly been on employment law. In terms of my practice, what you find in practice is whatever the underlying case is about, if it's a big case involving lots of international parties, almost certainly there'll be a jurisdiction dispute at the beginning. So the case I've most recently done is a huge fraud case where the Public Investment and Social Security Fund of Kuwait are suing their former Director General for $950 million because they say he took secret commissions and bribes. He's domiciled in England, so he's being sued in England by the Kuwait Public Investment and Security Fund. And they're my clients. We've then joined 18 other parties. Some of them are other fraudulent employees, we say, some are investment firms, some are banks who we say either deliberately paid secret commissions or helped to launder the money. So there's a huge case going on in England. 3 of those banks are Swiss banks, and the Swiss banks then say, actually, you can't sue us in England because there's a jurisdiction clause in a bank account you opened with us. So the underlying case is years away, but we now have a jurisdiction dispute between with these Swiss banks and us, and we're trying to say it should be England, and they're trying to say it should be Switzerland.
What's the name of this case, Louise?
The Al Rajan and the Public Investment and Social Security Fund of Kuwait. So it's been
something very similar came up with 3VB, but in any case, I'll separately would love to talk to you more about that. But.
So it's a really, and so why it's so important is that Swiss banks, of course, if they're sued in Switzerland, sort of can get away with anything. They don't want to be sued in London, where there's loads of publicity and everybody sees they behave badly and laundered funds, and so huge. It will probably determine the case against those parties because almost certainly they'll settle one way or the other.
Right.
They say it's got to be Switzerland because when you opened a bank account in Switzerland, there was a jurisdiction agreement, an exclusive jurisdiction agreement in the bank account in favour of Switzerland. We say that's like going to NatWest and opening a bank account with a standard term English jurisdiction clause in it. You don't, when you're doing that, envisage that we say, you know, the bank manager then runs you over on the way home. That's not going to be included in the jurisdiction clause. We say that the jurisdiction clause would not have been intended to cover a massive multi-party fraud, particularly including money laundering, which we didn't know about at the time, and which wouldn't have been intended to.
And which are my consent to opening this account, where that would never have envisioned.
Exactly, but there's a sort of so that's the. I mean, it sounds straightforward. So we had 4 days in the commercial court in lockdown that cost £10 million. Costs of that hearing. Yeah, unbelievable. We then have appealed, so we lost, coming clean. The judge said it was covered by the jurisdiction. In fact, what he said was that the fraud was covered by the jurisdiction clause, but the money laundering wasn't. But then he said, in any event, you had to keep the money laundering with the fraud, so it all had to be in Switzerland. So we then appealed to the Court of Appeal and lost again. And now we're trying to get permission to go to the Supreme Court. So, and the law's really difficult and it's really practically important. So people spend an amazing amount of money litigating jurisdictional disputes. There's a really interesting Brexit element to this case because it's decided, it was started before Brexit, so it's still under the old rules. It's a transitional case. But so we're still applying the Brussels regulation rules.
The president is going to set, well, obviously.
Well, yeah, although, so our problem is we lost at first instance. There's a European law point about joining different parties, which undoubtedly there's no cases on, and I think there would be a reference to the Court of Justice. So, under European law if it's act clair. So if it's clear, you don't have to refer, but there would be a reference on this. But the one thing you can't do post-Brexit is refer to the Court of Justice. So even if we're applying the European rules, which we are, because only a member state can make a reference to the Court of Justice. So we can't have a reference. We then
even though using the old rules, oh my gosh.
Though normally we would. So then we say, well, surely that means we should get to go to the Supreme Court. But of course they're saying, well, there's no public importance because after Brexit, all of these European regulations don't apply anymore. So we say, well, that's hardly fair that we can't make a reference and we can't have a proper answer for the Supreme Court. And the case itself is worth nearly, $900 million. And there's other transition cases, but we yet to hear. So we haven't heard yet whether they'll give us permission.
Wow. So what the position of the Supreme Court would also then be, this case has no precedential value because it's under the old rules.
And no public importance. So to get permission from the Supreme Court, you have to show public importance. I mean, everything I hear.
So interesting.
People tell me that the Supreme Court tend to just, if it's an interesting issue, they do it, and if it isn't, they don't. So I'm hoping they'll be interested in the issue.
It's really interesting, but I found a lot of courts tend to try to avoid anything involving large banking shareholder class action cases that could bring down.
Yeah, I mean, this is a Swiss
open secrecy or transparency. Yes, of course, because I think it's a dark view, but maybe half the Supreme Court have major accounts in Credit Suisse and UBS and would like things to stay the way they are.
These private Swiss banks, there's been quite a lot of bad publicity about private Swiss banks' behavior recently. So I'm sort of wondering if there might be a feeling of that they shouldn't be able to hide behind these jurisdiction clauses. And of course, it doesn't mean they don't, they just have to have the trial in London with all the other fraudsters, but that's the, that will be the argument.
Yeah. They just have to disclose a few, some documents, some agreements.
So I think that jurisdictions, it's just a really interesting area to be in, because, and the last case I did was about a rail accident in America. So when I tell the students about this, they go, well, that's interesting. And then I'll say, well, actually, it's about insurance. And they go, oh, that's boring. And I go, and in fact, it's not even just about insurance. It's about two insurance companies arguing where the case should be heard. And then they all go, oh, that's really boring. So, but it is really important. So this was two insurance companies who both insured the risk, and there was a rail accident. And one of them paid. And then they wanted to claim contribution from us, the other insurance company. And the question was, and we were French and we wanted it to be in France and they wanted it to be in England. And then there was a really interesting question about whether that was a contractual claim, because there were contracts. So each insurance company had a contract with the insured, but the claim was actually for contribution between the two insurance companies.
And there was no agreement between the two.
No, because it was a sort
usually
of
in an intercreditor, like,
they were separate. So it was a sort of equitable, unjust enrichment type claim, which does exist, a sort of, you've paid our share so we can claim, if they'd have sued us, we shouldn't have to pay it all because you were also liable for the same loss. But the claim between the two insurance companies was really a sort of equitable claim, which doesn't fit very well in the rules. So that was another, it raised some really difficult points of law. So I think these jurisdiction disputes are often very difficult and people will litigate them because they're so important in practice.
And lucrative.
I think in your papers, I also found the case you had with this German Air Berlin, I think, which was also a similar Air Berlin.
And and I mean, they often, it sort of doesn't really matter what the underlying case is about to a certain extent, because the jurisdiction issues are quite separate. And why that's quite good for me is because the hearings are usually only 2 or 3 days. And that does fit quite well with so I couldn't possibly do the trial of this. Well, I certainly couldn't now. Now I've got 5 million committees to go to every day. The trial of my Kuwait case will probably be a year, which would be hard for me to do. But the jurisdiction bits are usually quite separate. And in England, we do them first. So not all countries do that, but we have our jurisdiction hearings separately. And I don't know if anybody's got any questions on that, but otherwise I might tell you about another interesting thing I've done recently, which is sort of somewhere between academic practice and legal practice, which I hadn't come across before. But my head of chambers spoke to me and said, would I do a mock trial? You come across this, Juliana? So I think it's quite an American thing. So he was involved.
Your head of chambers mock trial?
He wanted to do a mock trial. Yeah, so really not
but
very.
3BB, I became a pupil, and then COVID happened, and then they did away with pupilages altogether. So that's why I went back to New York. But they constantly have mock trials.
So what happened with this was he was about to do a case in the Supreme Court, in fact, for Ukraine, really interesting. So the case was
that
really
is for training. Mock trial. I'm not a lawyer, so
well,
mock trial is for training or for preparing or playing.
It's for preparing. So what this was that the
you have a fake jury, the likelihood
all the
of,
options
So he was about to do this Supreme Court hearing on a really, really interesting point about whether a loan made to Ukraine could be avoided for duress, and this was a few years ago. And the duress was the threat to invade, which, of course, unbelievably, some of the hearing was about whether this was likely or not. But the key thing being whether you could avoid a private law contract by relying on a threat to breach international law. So it was a really interesting, and whether that was lawful act duress or unlawful act duress, and normally you can't rely on public international law unless it's part of national law. So it was a really interesting and difficult issue. And so what they did was they wanted to practice their arguments before the Supreme Court hearing. So I sat with Lord Hoffman and Lord Phillips and me, no pressure. So we were the panel, and they didn't, sometimes you get somebody from your chambers to argue the other side, which they didn't really do what they did. So you can do them in different ways. They just presented their argument and we tested it and we asked questions. And then just we didn't really give a formal judgment, but it was just a way of doing a practice hearing so that you can get some feedback and hone your argument and think about the things that will arise, which when you think about it really makes sense, because otherwise you spend all this time and money and getting
also the audience being judges, being you're not making this argument to lawyers who think a bit differently than English court judges who will want to opine for 50 pages on.
And it was useful because the two retired House of Lords judges hadn't read all the papers, it must be said, but they had a sense of the sort of arguments that will go down well, or they had one input, and I had read all the stuff, so I was able to ask sort of more detailed questions. And Bankim tells me he found it really useful, because otherwise you get to the end of your day and a half in the Supreme Court and think, gosh, I could really have said all that differently, or if I could do that again. And he said he really did find it useful, I think. And actually a really useful and interesting thing to do, because you sit with these amazingly eminent people and hear really interesting arguments and get paid for doing it. What's not like?
Do you do mock trials for students?
We do, and they do mooting more than a mock trial. So mooting would be... So
what is mooting?
Mooting's like, it is a mock, for some reason we don't call it a mock trial, but I think a mock trial would probably have witnesses. As an English, this is just a terminology thing, but at bar school we did mock trials where they had people pretending to be witnesses and you cross-examine them. A moot, spelled M-O-O-T, is just the legal argument. So you just have the two people arguing a legal point, and we do that a lot. The students do that a lot.
But there's a panel of, right?
So you have a judge, so you have a judge and you have the arguments. You just don't have any witnesses. I think
no calling witnesses. Okay.
Yeah. Well,
no depositions. No.
The mock trial I did.
Sorry,
no witnesses. So the students would tend to just do the law bit, but they do a lot of that. And I think
I was once invited to a private university in Kyoto for some discussions, and they had an old courthouse there, which was in the past it was a real courthouse, and now they use it for student training.
Yeah, I did it at bar school. When I was at bar school, I did that. I went to the High Court and did a pretend trial.
Okay.
But the students, we tend to, it's a bit, with the students, we just have a judge and they would just do the legal argument usually.
What was your most interesting case? Your most kind of passionate, most difficult, most...
Well, so the best case I did, the hepatitis C case was really interesting, but my favorite case was, I'm a very great football fan. And I knew it. This is the first. You knew you'd get to football. Right? Anything can become about football. You see, this is a proper answer.
You told me this the first.
I've got an excuse for football, but I was once instructed when I was at the bar first time round by the Football Association, with the same head of chambers, actually, who I know really well, who's brilliant, to represent the Football Association, prosecuting some players who had been given some tickets for a cup final free because their team was in the cup final, and that so they were given 10 tickets each. And some of them didn't use the tickets themselves, they sold them on the black market. Okay. Then at this particular match, there was some trouble in the crowd, which involved a video on TV of a man punching a woman in the crowd who were in the seats of some of these footballers. So it got terrible publicity, and the Football Association said that there was a sort of implied term in the way in which they were given these tickets that they wouldn't sell them for profit. So we were prosecuting these footballers who were actually footballers I'd heard of. So and the person who was the QC who was leading me is also a great football fan. So and the case was heard at, it was a Leicester City, they were Leicester City players, and it was heard at their ground, in the boardroom at their ground, with these famous footballers who we'd heard of. So we were being paid to do a case I undoubtedly would have done for nothing. So that's not a very serious answer, but that was, I'm afraid, my favourite.
Oh wow! But that was outside the traditional court system. That was
that was for the Football Association.
Private. Yeah. How would you call it? Mediation or? Yeah.
Yes, a sort of well, a disciplinary. It was a breach of it was a sort of breach of contract case.
Yeah.
And they were
be heard by a specific tribunal. Or
yeah, because they were impliedly subject to those rules because they were part of the Football Association. A bit like actually when I was a pupil, I helped, my pupil master was helping somebody who one of his children knew at the Oxford University Union Society had said this boy couldn't run for some sort of, like, I can't even remember what it was about now, but we went and represented him appealing some decision of the Oxford University. So that was a similar thing, a sort of private tribunal.
Gotcha.
The decisions can be enforced or
well, usually they're through the contract, really. So if you're a member of a club, which these are all sort of, they enforce it by, in this case, throwing you out of the club. I think the Football Association have fined these players, but their membership of the association involved giving them agreeing that they've got jurisdiction.
Like being a member of a convention, if you don't agree to the arbitral award, they can kick you out.
And what was the result? These players who are fined or
yeah, and it was I'm afraid that the Football Association, the procedure, it wasn't particularly fair. So the Football Association both brought the claim and were the judges in the hearing. So we won, but I'm not
jury,
sure
judge, executioner.
Yeah, I'm not sure it was a process which I'd want to defend in any real way. But it was an interesting.
I mean, it achieved probably the aim, because next time players who want to sell tickets are going to think about it again.
Exactly
before
right.
They do it.
Right. Yeah, no, exactly right. So that was I think my favourite case. I think that the hepatitis case was the longest trial I ever did.
That must be a life-death issue, no?
How long was that trial?
Case in Japan as well.
It was about 3 months. I mean, interesting law, because it was at the time that the blood was given to these patients. So it wasn't one of these it wasn't like Factor 8 where they were combining blood products. This was just normal blood that was donated in the normal way at a time when scientifically it was known that there was non-A, non-B hepatitis, but you could not test for it. There was nothing we could do about it. The blood if the patients hadn't been given this blood, they would have died. So there was no negligence, but they sued under the defective products legislation, which is a strict liability for defective products. So it was a very interesting legal case as to whether, well, first of all, whether the legislation should apply in this context, and if it did, whether that really is a defective product. If it wasn't a fault, it was an inherent, we lost, a sort of inherent feature of the product rather than a fault.
A fault within it, right.
But they said that wasn't the legislation just covers defective products, and it was a defective product. So,
there was a similar case in Japan, but I don't know the details. It's outside my range.
I think some of the blood cases are different because, for example, if you collect blood from different people, that causes a much bigger risk. And some of it was at a time when you could have done something about it. But this was unusual because it was undoubtedly there was no negligence here, and the patients would have died, or something like 50% of the people have
had it not been done. Right.
Yeah, so, and the quantum was also very difficult because some people who get hepatitis C don't get ill at all.
Right, what's their loss? Exactly. No,
and some people get very ill, but having it hanging over you was quite a difficult thing as well. And that became the leading case on defective products for a long time. The difficulty is it's very hard. It's not negligence. So if it had been negligence, we'd have won. We definitely weren't negligence. But it's very hard to try and explain where it comes. So therefore they said, well, it's not negligence,
who messed up.
it's
yeah, right,
defective products. But it sort of wasn't defective in the sense that there really was nothing we could do about it. So not only we were not negligent, it was give the blood or nothing, but they just said that's what defective products are about. There is no, it doesn't have to be a fault. It just has to not do the job that a reasonable person thinks it should do.
Ethics questions important. Michael Banner gave us a wonderful talk here about two talks actually in consecutive years here at our dinner meetings in Tokyo. He was, I think, on the ethics board of the NHS, or I don't know what the word for it is. Is your work, let's say, for the NHS in these issues, where hepatitis, for example, is involved, is that connected to ethics issues as well, or is it a purely legal argument?
Well, so I think that what happened in my case was, I think the legal case is the legal case, and the court came to a decision applying the European legislation on consumer products. What subsequently happened is there was an inquiry, and then there, I think, isn't more of an ethical question as to whether there should just be a no-fault compensation regime for all this. So rather than spending time having to prove that some people have got a claim, so what happened with some of the patients is they got the blood before the legislation came into play.
Okay.
So in court, you can't do anything about that. That was a legal claim. There has subsequently been an inquiry which has looked at much broader issues, including the ethics of, I mean, I don't think with our case, there was no, as far as I'm concerned, there was no ethical question really, because either they got the blood or they died. But I think the question of how you deal with it and whether you should have a blanket compensation, there has been subsequent, and lawyers did appear in that inquiry. I think actually the master appeared in one of these inquiries as well. But yes, so I think that, but I think the court case just had to deal with the law as it was, which is often a blunt tool, of course.
Maybe the question of quantum, though, or sentencing, that ethics plays a bias,
yeah, and it was,
a silent role.
The blood authority who I was representing, it was really sad because they were so conflicted by what happened, even though actually there was nothing that they could have done about that. Right. But they knew the risk, but they couldn't at the time. There was no test for it. So, but it was a very difficult. I think they'd have rather just paid the money actually, and they didn't appeal.
Yeah.
Maybe there are two people here, maybe, or three, who haven't asked any questions. So if you like, Louise, would you mind? I'll ask Hilary from Dublin. Hilary, are you Hilary? Hilary, she doesn't respond. I have one, if you like to. We have a very young friend here, Leo Lee, who is from a famous school in Hong Kong, and he's a student and he's thinking to apply. So he's
okay, yes, Leo, go ahead.
So Leo, do you want to ask a question if you have one? Leo?
Sure. Yeah, I know this is an alumni event, but then yes, I was just listening, and I was wondering, as a very distinguished lawyer, and I'm very humbled to be here today. I just want to ask one question on how, as a very distinguished lawyer, what is a motivating factor that drives you forward in this long career?
That's a very good question. I mean, I think there's the different strands of what I do, I think, have different motivations actually. So my academic career, I would say I've been probably most strongly motivated by the teaching element to it, which is interesting because I haven't really talked about that yet. So thank you for that question. So I've written a book on international employment law because that's what academics do. But actually, what I really like and why I really like being an academic lawyer is to teach the students, and particularly supervisions. So that's definitely what motivates me more as an academic, I would say, than writing. I don't mind writing, but it really is the teaching. I think as a practicing lawyer, I'd like to, I mean, my case is, as you've heard, it's not as if I'm not doing things which have a sort of human rights I think it's the intellectual challenge, really, for me. For the cases are really difficult, they're interesting. To get it right, to think of the best arguments is just a really interesting intellectual challenge. Being Vice Master, I think I just have really enjoyed the fellowship of the college, and it's really meant a lot to me, and I really enjoy being part of the college. So that my motivation there is actually just to try and make the college a happy place, and if I can change small things, great, but really just steady the ship post-COVID, try and make it a community that exists for everyone, for the students, for the staff. That sounds a bit wet, but that's, I think, as a Vice Master, I'd like it to be a happy ship that enables everybody to get the best out of the college and do the best they can. So I think it's an interesting question, and I sort of hadn't really thought about it, but I think probably there are different answers to the different things I do.
Thank you so much for your answer. Yeah, I'm just a very young person, and I'm still thinking about my future and thinking about my career. So it's great to hear from very distinguished people in this field. Yeah.
Well, I think you can do with a law degree, you can do different things. And I mean, I've done lots of different, and who knew I'd suddenly be the Vice Master, and that's a lot of my time now. So I think there is always, my children will be going almost, but yeah, whatever you do, there's always flexibility. And actually you're having a change. I mean, I really enjoyed coming to Cambridge after being at the bar, but now I've enjoyed going back again a bit more, actually. So I think variety, which I think for your generation is a much more common thing anyway. People don't just do one job forever. And I think that can be a really interesting experience to do different things.
Thank you so much.
Thank you, Leo, and thank you for your initiative. I was very surprised and encouraged to have you join here. Sometimes students join, but very rarely. So you must be one of the really initiative people with a lot of initiative. Hilary is not here. Hilary, Martin, do you have a question? Do you want to ask something, Martin?
I've been listening. Actually, I'm terribly yes. The reason I haven't been visible is that it was also an extremely good opportunity to do my ironing, because I could hear every word. It was a matter of moving practical things forward. I'm way back when I was thinking about sort of applying to Cambridge and applying to Trinity. And my first thought was that I would try and do law because it seemed to offer, well, career paths and things of that sort were interesting. And my mentors at school basically said to me, no, you should do a pure subject. So I went for history, and I ended up doing architecture, but came back to history, actually. And that's for me been a kind of quest. And so in that sense, I think it was for me a right decision not to do law. But I'm interested in, you say, and I can see that it is an intellectual challenge, that you've got a case and then you've got to find a way of arguing round it. But where would you place research in that, if you're kind of trying to expand borders? I mean, thinking about what the framework, say, of the law, the legal system, or whatever should be. Do those sort of issues engage you, or is it really a matter of helping students to master the mechanics of how you argue in every given case?
I mean, I think depending on one of the advantages, I think, of doing a law degree is that it is so varied. So if you were asking that question to a jurisprudence lawyer, of course, their answer would be, that's all I do, or a public international lawyer. So my law is what we would say is more black letter law. So it is a bit more closely subscribed to what the answer is. But even in what I do, I think one of the things I try to think about as a private international lawyer is that you need to understand the underlying concepts in order to be able to apply the rules. So which isn't quite what you're describing, but it does definitely have a theoretical element. So if it's an employment case and we're saying the particular rules should apply to employees, well, that might actually require you to think about who are we counting as an employee here. So all of the things about Uber drivers and the gig economy, my own view as a private international lawyer is you can't actually apply the rules properly without a really proper conceptual understanding of the underlying subject matter in quite a sort of categorization type way. But categorizing isn't just about applying a rule. It's about really thinking about, why are there special rules about employees? It's because they can't protect their own interests. It's because you can't rely on the contract of employment because their employer will have written it. So I think it does require a conceptual understanding as well as just applying the rules, which is why I find it interesting, because even in my field, which is quite a black letter field, it does have justice concepts as well. You know, should the case be heard in England? Sometimes that's yes, because that's the only place you'll get a fair trial. So it's not quite as dry as it sounds. So even though you're ultimately doing quite a technical thing, I think there is a broader hinterland that usually informs the decision. And I think the thing about a law degree is I always say to students, so I have been an admissions tutor and saying to my own children, if you really love a subject, history, then just do history and you can always be a lawyer. If you don't love one of your A levels, then law can be good because it has got a variety of skills. It's got some legal history, it's got philosophy, it's got, you know, criminology is really interesting, social policy. So I think it can be a really good thing for sort of all rounders students who don't particularly just want to do one thing and don't love one thing. Yes. But I think if people love one thing, then I wouldn't persuade somebody to do a law degree, I think.
I mean, its career path is clearly, that's where it really wins in many ways, that there are so many things and so many different sorts of careers, specific careers in the running of the world, as it were, and the running of business and everything, to which it will connect, and something like history doesn't, which is why I thought, having started with history, better do something that would be more sort of obviously about making something for society. And my father was involved in architecture, so that kind of led me into that. But it was interesting that as it went on, the interest in history resurfaced, and I was lucky though that it did connect to a career, because it could easily not have done, or it's teaching and that's it kind of thing.
I think that the skills you get as a lawyer as well, and I talked about being the vice master, I think that process,
presenting to an audit committee, even
I think it is useful. It does give you some skills of balancing things. I don't know, but I mean, everybody does this. History, you have to read loads of material and apply it. And I'm not saying
I think the speaking skills are very, very valuable. Like, I could convince myself I'm right in my head, but then I'd have to explain it to you in a supervision, logically, rationally, concisely, and that's helped me a lot. In transitioning, I worked for the DOJ, worked in private practice, the barrister, and now in New York, I'm actually head of legal for an investment bank. And so, everything I've learned from Louise has been, completely on the dot, and could not have been better prepared.
No, they'll think I've paid you to come, Juliana. It's very kind of you to say.
No, honestly, I'm honored to be here, and so much thank you for. But I'm sorry to have been asking so many questions. I meant to save them for when I see you, but
no, I think it's been very helpful to have somebody who knew what sort of questions to ask, because that way you prompt interesting discussions that we who don't know so much can learn from. So that was really very interesting just to listen. And I can see too how, Louise, how your practical legal skills make you an ideal person to be working as vice master, helping to run and help a college to engage with the issues about its own day-to-day running and so forth. And obviously people are needed who do that on the academic staff, and people who are more deeply into a specific research project, as you said, would find that difficult to engage with.
One thing, may I ask you, Louise, one thing I'd be very interested to hear is your interactions with Sarah Worthington, who also gave us a very, very interesting talk. And she, I learned so much from her just by preparing and then having the discussion with her here on equity. which I'm not a lawyer, so I didn't know much about equity at all. And she went completely the other direction. I think she came from science and then she switched from science to law. Maybe, you are both both women and both key people in the law department of Cambridge University. Maybe you can tell us a little bit about your interactions with Sarah. That would be very interesting for me to hear as well.
Yes, so Sarah and I, and so we obviously have worked closely together in college and at the faculty. I think she had an interesting perspective, partly from where she's come from, so from science and she did do a PhD when she had her children, but also she came from the LSE. So I think it's very useful certainly for the law faculty to have named chairs who come in from other institutions, because she had some very interesting ideas about how they did things differently and how they did things the same. Her work, equity, I did used to teach equity a long time ago before Sarah arrived, and I used to find it incredibly difficult. And with the thing I teach, conflict of laws, I used to say this to Juliana and all my students, you sort of can get the answer right if you do it in a logical way. I used to open the equity exam and think I don't even know what the question's about, let alone what the answer is. So it's quite a different style of subject. The students find Sarah incredibly inspiring, but also quite scary, I think, because it's a very, I think so, yeah, she's a very demanding subject. It is a very demanding subject. So Sarah's retiring this year. She's retired. She's retiring from her university job. But I've managed to persuade her to come onto the buildings committee at college, and I'm hoping she might help me with the master plan. So I'm really looking forward to. She's very interested in housing. She's got a really interest in the buildings. So I'm hoping that we can keep her involved. And she's still teaching equity for us. So actually, I'm hoping she might have some more time to be involved in college now she's retired from her university job.
I invited a professor from Kyoto University for international law who has no connection to Trinity, but I invited him and he joined the discussion, and he had in the middle of his bookshelf was Sarah's book on equity. So she is very well known in this field, including in Japan. And I was looking actually at traces of the concept of equity law in Japan. And I found some books by a law professor in Nagoya who wrote about, concept of equity in Japan. While Japan law, I'm not a lawyer, but the picture I made myself of Japanese law is that it's quite interesting because, of course, Japan as a country has a very, very long history, but our concept of law only entered Japan at the Meiji period, like in 1850 or something. Yeah? So there's a very interesting mix of, completely different concepts. And on top of that comes the Western concepts of law. But, this is as much as I can talk about it. I mean, it's not my field at all.
There's a very interesting which countries have a civil code, which is compared to common law countries, and countries with a civil code, like all the European countries, would tend to say that they don't have equity. But when you think about it, they don't have it called equity, but they must have, they have companies and they have pension funds and they have directors' duties. So we do it in a different way, but other systems probably are more similar than you think. When you think of most systems run pension funds in the same way and have ways of people holding assets for other people, but they structure it in a different way.
When you saw international law, I mentioned this Michael Woodford case. Have you been involved with Japanese cases as well, or some Japan touch on it, or not?
I don't think I have.
Didn't you have involvement in the antitrust, the auto parts as well?
I did an antitrust case recently.
Competition law.
In the Bahamas, and I don't think I have had any. And actually, I have been looking in a sort of broader context about some of the new international courts in Singapore and China, but I don't think I've had very much to do. I was at a Hague Conference that was hosted in Japan.
Okay.
So the Hague. So because we're now no longer in the European Union, we're looking at broader internationalism, I think, in private territorial law. And one of those is the Hague Conference, which is a really big organization, and that they produce they've recently done a convention on choice of court agreements, which has had very widespread support. So, and that was hosted in Japan, actually. So I think there will be a move to be more broadly international following Brexit.
If you come to Tokyo, please join. Let me know, certainly. And we'll organize an event for you here.
Yes, well, I'd love to go. I'm trying to persuade the alumni office that I need to do some traveling for alumni. It's about time I got to go on some of these trips. Now I'm the vice master.
At the moment, it's hard to travel into Japan.
Yes, I read there was something in the paper today that said you were allowed to travel with a chaperone. Did you? There's something in the
yeah, but there's Japan is a democracy, and there's an election in summer, and the reality is that, from what I hear, is that the majority of voters seem to prefer to limit foreigners because of infections and fear of infections. No? And so the government has one pressure from business community and tourism industry and so on to open up, and another pressure, I guess, from the population that they are more careful about getting infected, and that will switch. That the balance between these forces will switch after the election. So after August, I think the election is in August. I forgot now, July, August, and after that, it might open up more.
Okay, good. Phil wants to come too. Yeah, Phil, we can arrange. I think we need to insist on an alumni visit to some
Michael
nice
Banner came. Actually, we had a number of events here, but Michael Banner came twice. And,
yes, I know he's been twice. I'm aware of it. I've seen his travel schedule. I think it's about time we got onto that.
We have also several fellows, Trinity fellows, have Japanese wives, and Dominic Leven. Do you know Dominic Leven?
Yes, I do, and I know his sister's a judge. Yes, I do know him quite well.
Oh, that I didn't know, but he just wrote a book on emperors, and he gave us. Also, he's very knowledgeable about the circumstances of the Ukraine situation. And so he gave us a wonderful discussion here on a similar event. At our Zoom event on the Ukraine situation. And he joins almost half our dinners because his wife is Japanese partner, and she lives here, I think. So he spends a lot of time here in Tokyo. I think, as I remember, I think your time is coming to...
Yes, it has. I better get to my meeting.
I think I don't want you to be late for...
No. For marking, actually, I've got to mark exams and go to an exam marking meeting.
Oh yes, I love this. I used to do that.
That's not my favorite thing. Talking about my motivation to do that is very low. Sorry?
Are they handwritten still, or are people getting to type them?
The types now.
Not so unfair.
Well, Louise, thank you so very much for this.
It's very good to speak to you all.
Fantastic event. This was so wonderful to talk with you, and you've inspired so many of us, especially Leo here, who is thinking where to study and how to study.
Well, it's lovely to meet you all, and Juliana, lovely to see you. Let me know when you're in Cambridge.
Absolutely, will do. Thank you so much.
Okay, bye everyone.
Thank you very much.
Thank you. Bye-bye.
Thank you.